Almost on cue, the judge eases the atmosphere with a touch of small-town nostalgia, tossing out a light comment that draws a few faint smiles and gives the room a moment to breathe. It feels casual, almost disarming, the kind of exchange that reminds everyone this is still a human space, despite the weight of the proceedings. But anyone familiar with courtroom dynamics knows better. These lighter moments often serve as the calm before the storm. It's the judge's way of resetting the room, lowering defenses just before delivering the harder blows of consequence and accountability. In a setting where words carry the force of law, even nostalgia can set the stage for impact.
Yes, sir. 25CR144 is called, and you were Shelby Nicole Celerandi.
Yes, sir.
Used to be, when I was growing up, Weaver Celerandi.
That was
Automobiles.
yes.
That was the big car deal.
Right.
Weaver Celerandi. Two names, two different people. Probably got to be related. How many Celerandis are there?
Right.
Got to be related to something.
But I felt like
Are you driving a new car?
She's not. She has her DWI. So
I know. I was asking.
I have, sir.
Last time she was here, I believe Mr. Kimler had not been hired yet, but he had filed a notice, and she had had her bond raised because she threw a drug test in the toilet.
Okay, you, as you know, you were charged here with a third-degree felony of operating a motor vehicle in a public place while intoxicated. And it's a third-degree felony because you have 2 prior DWI convictions here.
And here's the legal kicker that changes everything. This isn't her first appearance on a DWI charge. It's her third, with 2 prior convictions already on the record. The law no longer views this as a lapse in judgment or a one-time mistake. By default, this new charge automatically escalates to a felony. That shift carries enormous consequences because the justice system treats repeat offenses as a clear pattern of behavior rather than isolated errors. At this stage, it's not about second chances anymore. It's about protecting the public and holding a defendant fully accountable for choices made again and again. What might once have been probation or a short stint in custody now carries the much heavier weight of long-term penalties.
I'm sorry.
Yeah, there was, well, these were blood alcohol 0.226 and 0.231, which are about 3 times the legal limit. But it wasn't drugs, it was alcohol. You have some kind of a device on, do you have an interlock device on your vehicle?
Yes, sir.
You have to blow in it before you
Yes,
can
sir.
start the car.
That's just been done. So I don't even touch my car.
You don't even operate a car?
No, sir.
Oh, well, you can do less damage that way.
All
That's
right,
true.
because I'm suspended. So I can't even get in there.
Well, you can't operate any motor vehicle without an interlock device. If that happened, your bond would be revoked and you'd sit it out in jail until we can dispose of this,
Right.
because that's too dangerous for others and yourself. You have a drug patch too?
Yes, sir.
You have a drug patch?
Yes, sir.
Okay, as well.
Yeah.
That's because you tested positive for cocaine and meth last time, right?
Yes.
Take note of this detail, a drug patch. Think of it as a silent, wearable watchdog, almost like a lie detector stitched into your skin. It continuously monitors sweat for traces of illegal substances, leaving no room for excuses or carefully timed detox tricks before a scheduled test. Unlike traditional screenings, there are no warnings or appointments to prepare for. The patch is always on guard. If it detects drugs, the evidence is automatic and undeniable, essentially catching someone red-handed before they ever step back into a courtroom. In other words, it's not just a condition of release. It's a constant reminder that accountability doesn't clock out, and every choice beyond the courthouse doors is still being measured.
I see, it's there. I see it.
Yeah, I see it. Okay, how often do you get that changed? You got to change it so that they can test it to see.
Right.
Or
It was today. It was, I thought,
today they're supposed to do something? They're going to take it off and test it today, and is that what they're going to do? Is
yes.
that what you're saying?
It was supposed to be yesterday.
But what happened yesterday?
I thought court date was yesterday, but it was 17th and somebody changed it to the 17th.
That was not, it was supposed to be in trial, and so Elliot changed the dates.
That wasn't me. I was
That
very-
was-
She was actually set, I believe, the day before.
Okay, what were you going to do to her? What did you want?
Well, with her, just that would reset it for an announcement. I think today was just a day to make sure she was compliant with the bond, but we completely discovered, so we'll just have her set on.
Yeah, it is. It is an announcement there.
Could I have a little bit of time to look at the discovery?
Yeah, you went 4 weeks.
This was.
Okay. But we're going to test her before she leaves. Even though she's got the badge, I want to know where she stands right now.
Okay.
Okay, just have a seat right over there. And then 4 weeks, reset 4 weeks. Thank you. Hey, Brian.
Yes, sir.
Justin, Barry.
Yes, sir. He's present.
Yeah. 3 cases, Brian.
Great. Yes, sir.
11 minutes later.
Yeah, come on up. And
Oh, there's some.
yeah, and benzo guys, but I mean, I don't know her, but I'm pretty good at what looks normal, and she doesn't look good right now. Not that you're not an unattractive lady, but you look like you're bewildered, and you look like you're intoxicated with something. We see it every day. We know it.
Look at how outrageous this is. The defendant appears in court seeming intoxicated while already facing charges for intoxication. It's the kind of move that defies common sense, like arriving at a firefighter interview while holding a lit match in plain view. The irony is almost unbelievable, and the courtroom quickly shifts from routine to disbelief. A judge doesn't need long to cut through the act, and in this moment, the performance collapses instantly under scrutiny. What was likely meant as confidence or denial turns instead into a glaring reminder of poor judgment at the very worst possible time.
You tested positive for alcohol, which you shouldn't have, and which is what you're in trouble for, among other things, and benzodiazepines, which is a controlled substance. What is your plan?
You have a prescription. Appraisal one?
Yes.
You didn't drive up here, did you?
No, so my mom was right there.
Did she live with y'all, man?
No.
No. She's free falling. She's free falling.
Her bond's $20,000.
You know, family needs to help out on that, because I can only put her in jail. I can't get. I can order help at some time, but where's her funds?
Oh, it's right there, but you get it back.
She indicated she does have a prescription for appraisal. Explains the benzos, but of course that alcohols.
Yes, because it was 3 times the legal limit for alcohol on the offense. What is her bond again, please?
20,000.
Yeah. All right, your bond is revoked, and it is now doubled to $40,000. That's what happens when you violate the terms and conditions of your bond. You have a drug patch, correct? You have a drug. Yes. Okay. All right. We've got to now do something with the alcohol.
Well, he's here today.
And
I believe it's scram, was it, Your Honor?
what's the best thing for?
And there it is, the hammer comes down. Violating bond terms isn't just a matter of irritating the court. It strikes directly at the trust built into the release process. The consequence is swift and unmistakable. Her bond is doubled on the spot. No delays, no negotiation, just immediate financial and personal impact. Judges enforce this kind of punishment deliberately, not merely as a penalty, but as a message that echoes throughout the courtroom. The warning is plain. If you can't respect the basic rules while free, then you won't remain free at all. In the eyes of the court, bond is a privilege, not a guarantee. And when that privilege is abused, the only place left to wait is behind bars.
This situation where we got drugs and alcohol.
There you have
Right.
The scram device? Okay, you must have a scram device as well. And that stands for, it's an acronym. But both of those devices are going to be a condition of your bond.
I'm sorry, you said screen device?
Yes, and continue, and she has to have a drug patch as well, which is costly, but something needs to be done to figure out how this is going to end up, because you're showing up to, you're not only in public, get in trouble operating a motor vehicle, 4,000-pound missile while intoxicated. Now you're showing up in court and you're inebriated, and it's just you got alcohol in your system and drugs in your system, which don't help clear thinking and resolving this. You need to do better, or else it is a catastrophic end. Anyways, those are the findings, and you're taking them to custody.
That was what's called.
Is Victor Davis here? The bailiffs, you're in custody. The bailiffs are in control, ma'am. You have to follow their orders. Thank you. Victor Davis, there is no answer.
The hearing ends with powerful words from the bench, words that cut through any lingering doubt. Driving drunk, the judge stresses, isn't just reckless or careless. It transforms a car into a 4,000-pound missile, a weapon capable of devastating lives in seconds. Add drugs into that equation, and it's not just risky, it's a near guarantee for disaster. The severity of the message hangs heavy in the air, and the defendant, once clinging to excuses, can no longer ignore the truth. For her, the reality has sunk in, but it's too late. The damage to her case and to her future has already been done. What lingers isn't just a sentence, but the sobering reminder that choices behind the wheel carry consequences far beyond the driver's seat.